Hello and welcome to Spardha Lines, your one-stop destination for the civil services preparation, UPSC, KPSC and other relevant examinations. Today we will discuss some of the important articles that have been in use in the Hindu newspaper, which can be important both from your pre as well as your mains examination perspective. Let's get started and look into the first article. The first article in the Hindu is speaking about the mediation bill. The mediation bill was recently given assent by the President of India and it eventually goes on to become the Mediation Act. So in this article, what we will try and understand is what is this Mediation Act all about? What is this alternative dispute resolution? What are the features of the Mediation Act of 2023? What is the significance of it? And what is the way forward and advantages? Everything will be discussed as part of this Mediation Act of 2023. First, we have to understand the meaning of what is called as the alternative dispute resolution. What is this alternative dispute resolution? As the very name denotes, there is a dispute between the parties. So there are two parties who are involved in a particular dispute. So there is party A and party B. They have a dispute. So instead of going and resolving this dispute in the form of a court, so they go to the court, there is a litigation between the parties. They go to the court and ultimately the court will conclude in favor of one party against another party. So this is what is going to lead to litigation. So in litigation, a party goes to the court, files his claim and the court looks into the claim and ultimately provides justice to one of the parties whosoever is the claim which is right. So what happens in the litigation? You have a party going to the court seeking for his enforcement of the rights and ultimately the court will look into these claims and provide the rights. So this happens to be a cumbersome process. Why? Because when it comes to the court, what you have is a long procedure. This will lead to uncalled delay as well, and this can also lead to reputation of a company going at stake because it is under the watchful eyes of the people. So when they go to the court, you will have one party filing a case against another party. You have a lot of procedures that come into place. This could lead to undue delay as well, and it is also a costly affair. In order to reduce all this, what we have is an alternative. Alternative to what? I don't have to go to the court of law, but instead I will approach an alternative forum, and that alternative forum is what is called as the mediation, arbitration, conciliation, so on and so forth. So instead of me going to the courts, I will approach an alternative forum. That alternative forum where I can resolve my dispute is called as an alternative dispute resolution. So I'm resolving my dispute through an alternative forum which is called as an online alternative dispute resolution. When this alternative dispute resolution is taken on an online platform, that is what is called as the online dispute resolution. So when you're meeting offline, when you're able to see physically, when you're able to have any tangible meetings between the people, that is called as an alternative dispute resolution. An aspect of alternative dispute resolution when it goes on an online platform is what is called as the online dispute resolution. So what happens in online dispute resolution? Parties do not meet physically, but they are connected via the use of the telecommunication means, and a person may be seated in one part of the country, another person may be seated in another part of the country. They discuss, they deliberate and ultimately draw a conclusion to their dispute through the channels of communication, making use of the information technology. So an aspect of alternative dispute resolution happens to be online dispute resolution. So in online dispute resolution, what you will also have is a mediator, an arbitrator or a conciliator, and you will also have the presence of the parties online platform where they make use of online forums like Zoom or Google Talk, so on and so forth. So what is this online dispute resolution? There are different aspects of online dispute resolution. You have arbitration and conciliation, which is part of the Arbitration and the Conciliation Act of 1996. This 1996 Act has also had subsequent amendments in the year 2019, so on and so forth. but we did not have a specific law with respect to the mediation. Yes, it was part of it. It was part of all the divorce matters. Mediation was already in place, but then we did require an act as well, so that is also taken into the picture. So an explicit act only for the mediation had to come into picture, and that is why the government has introduced the Mediation Act of 2023. So we had the Arbitration and the Conciliation Act of 1996, subsequent amendments in 2019, but we required one for the mediation, for which the government has come up with what is called as the Mediation Act of 2023. So what is this Mediation Act of 2023? First, let me give you a brief idea about difference between arbitration and mediation, and then we will also discuss it eventually. But for you to understand the difference between arbitration and mediation, let me give you the difference. What happens in arbitration and mediation? When it comes to arbitration, what you will have is an arbitration award. This arbitration award is equivalent to binding in nature. Let's say you have a trial court. The trial court is going to give you a mandate that you have to follow so and so orders given by the court. Similar to that, what you have is an arbitration award being made by the arbitrator. So whatsoever is the award given by the arbitrator, the same has the same meaning similar to that of the civil court. So an award is binding in nature, but a mediation is not necessarily binding in nature. So in arbitration, the major key point is it is binding in nature. Parties will have to comply by it. They can go on an appeal, that's a different thing, but then it is binding in nature. But when it comes to mediation, it is not necessarily binding. So what are the major provisions of the Mediation Act of 2023? This act requires every mediation agreement to be in writing, which means to say that it has to be in the form of a writing written on a piece of a paper. So it can be in a form of a document where you have all the clauses that are inserted, you have valid enough points as well. This is written on a piece of the paper, and then you would also have parties who look into this entire piece of paper and they also give their sign as well. So it is on the paper. Then it can also be through an electronic communication. What is an electronic communication? Let's say, for example, I have sent an email to you, you have acknowledged the email and you have reciprocated back replying on the very same email. Or I have sent you a WhatsApp message, you have accepted a WhatsApp message, you have reciprocated back with the WhatsApp message as well. Or it can be through the electronic communication. So if I'm making use of the electronic communication or the document or by a court pleadings as well. So there is a particular case that is ongoing between me and you in one of the case matters, and in that pleadings I have also referred to this clause which says I'm going to refer so and so case to the mediation, so on and so forth. So if there is an explicit mention of word called as mediation in an agreement, so we have entered into a contract, we have an agreement that this is a particular case for, that is I'm going to supply you so and so product, you're going to accept so and so service, so on and so forth. An agreement has been entered between myself as well as you. So what do? In that particular agreement, you also insert a particular clause which says that in case we have a dispute between each other, that in case there is an eventuality, there is a violation of a certain terms and conditions of a contract or an agreement, what would happen? We would first go to the doors of the mediation center or arbitrator, so on and so forth. So what we have is an agreement which clearly says that for so and so conditions we have so and so provisions, that I will be giving you so and so service or a particular good or a violation. In case there is a violation of a goods or a service treaty, then we will first approach the arbitrator or a mediator. So it should be in writing, it should be in a documental form, it should be in an electronic communication, and we need to have an agreement to it. The agreement can be an independent agreement only speaking about the mediation, or it can be a clause within a major agreement. So what is the primary thing? First thing is it has to be in writing. What if there is no writing? We do not have the agreement, we do not even have a clause within an agreement. In that case, they can also voluntarily go as well. Let's say, for example, there is a dispute between me and you. We are a company which is running, I have entered into a contract with your company that I would say I would provide you so and so diodes or the transistors for your company, but there is a violation with respect to the contract agreements. So instead of us barging to the courts, what we actually do is we voluntarily, I communicate communicate to you, please don't file a case. Let's communicate and understand the discussions and let's come to a consensus. So what do? Voluntarily and mutually, we refer this dispute to a mediation prior to filing a suit or instituting a proceedings. So it is not that it is compulsorily required that we need to have an agreement in place. If it is an agreement in place, it has to be in writing. Even if there is no agreement, that we have a consensus between each other. I say that I'm requesting it to you, you are accepting it. So let's go to the mediation center and resolve the disputes between each other, and that is another point that can be taken with respect to the Mediation Act. So disputes involving criminal offences, proceedings initiated with respect to the misconduct of any registered professional, and disputes relating to levy and collection of direct or indirect tax or refunds will not be part of the mediation. So the mediation can be with respect to a contract and an agreement or a consensus that you build because you have a dispute, but that mediation cannot be happening with respect to the disputes involving criminal proceedings. So what if there is a criminal case and every party does not want to go to the courts, do not want to get penalized? There will not be a proper society, a social contract. There will be utter chaos and recklessness in the society, because criminal cases is never ever part of arbitration or mediation. A criminal case is always susceptible to be heard before the court of law, and it is only the court of law which will decide on the criminal matters. So criminal matters or tax related matters or misconduct of any registered professional will not become part of the mediation. And when it comes to the mediation, what they will also have is the mediators. These mediators will be a panel of mediators who would give their names to the court of law. The court of law will have the list of these mediators. So similar to how arbitration works, you will have a list of mediators who will be part of an institution. So the parties will approach the court. The court will say these are the mediators that are present. So both the parties give consent to it, that they'll have a list of names. So the court will suggest that you have the person's name as A, B, who is part of the mediator. So the parties can select who this person can be and ultimately take their case to this particular person. So there will be a panel of arbitrators. So the minute you file an application before this mediator panel as an institution, within 7 days from the receipt of the application, the mediation service provider shall either appoint a mediator as agreed by the parties or a mediator from the panel maintained by it. And then whenever this case goes to the mediation, within a period of 120 days, they have to decide this entire case. So it goes to the mediation center, you will have a mediator, the parties discuss. So from the first hearing, within the next 120 days, they have to finish it off, and this can further be extended to another 60 days. Sorry, this is not 80 days, this is 60 days. So all in all, it will be about 180 days. So first 120 days, they have to finish and address it, and next 60 days, they will be given an extension of time, and within those 60 days, they will again have to comply by it and ultimately finish the entire proceedings. But meanwhile, in case there is an urgency, in that case, they can also go to the court as well, seek a temporary injunction or a stay, and then get back to the mediation. What if there is an exigency? In that case, it will take at least 120 days, another 60 days to entirely complete this entire saga. So meanwhile, in case they require a temporary injunction or a stay, they can still approach the court, get back to the mediation proceedings. So a mediated settlement may be challenged only on the grounds of fraud, corruption, impersonation, where the mediation was impermissible under the Act. So if it has happened by a fraud or by a corruption or by an impersonation. What is this impersonation? Let's say, for example, there are two companies, company A and company B. Company A has signed a contract with company B, and there is a clause in that particular mediation. There is a clause with respect to the mediation, but there is another person who does not even belong to the company from company B. He comes and he says that I belong to company B. He signs the ultimate contract, and he says that this person is the right person to sign the contract, but that person doesn't even belong to the company B. That is impersonation. So if impersonation happens, that a person who is not legitimately belonging to the company and signs that agreement, he is not eligible. In that case, they can again file a case. So these are the major provisions of the Mediation Act of 2023. Now, what is the advantage of it? The advantage of it, we know for the fact that there are crores of cases in the Indian judicial system. We've always heard this quote that there is justice delayed is justice denied, and when it comes to the litigation, it is a costly affair, it is a long affair, because it takes, advocates keep taking adjournments after adjournments, they take long time as well, they also have to prepare as well, there are other exigencies that may also step in, there are parties who always have to come and speak to the advocates, they have to communicate to the advocates, there is facts on one side, there is law on other side, that requires a lot of reading. But when it comes to mediation, they need not have to compulsorily follow the procedure initiated under the law. When it comes to the court, you have the code of the criminal procedure, you have the civil procedure code. So let's keep aside the CRPC. We have the CPC, which the courts will have to follow for all civil cases. But when it comes to these mediations and the arbitrations, they don't have to strictly follow the code of the civil procedure. So that means the delay can be reduced, and ultimately what they will get is the speedy justice system. So then whenever you go to the court, you will have one party who also wants to teach lesson to another party. So they file cases, there is another party who will not have any issue whatsoever, but then because the one party has filed a case, the other party has to run this particular case. So there are frivolous claims that are filed in front of the courts, and this takes years to discharge this entire case as well. So this ultimately leads to delay in the process, whereby frivolous claims are also filed before the honorable courts. This can also be prevented, because when it goes to the mediation, the mediator will understand whether it is a legitimate claim or not, and if it is not, it can be immediately be suspended. At the same time, let's say for example, when it comes to the court, it is a public affair, which means there is open court proceedings that happens in the court of law. There are two parties in this particular case. Let's say there is one party A, there is another party B. Let's say this party B happens to be a cab aggregator, which means, let's say for example, Ola or Uber. There is a customer, I have taken the services of Ola or Uber. This is just for the sake of example alone. So what if I don't like the services of Ola, or what if I don't like the services of Zomato, or what if I don't like the services of Amazon or Flipkart? What do? I immediately go to the consumer forum, and after consumer forum, I do not like the compensation that they have given, I go to the higher courts as well. So in this particular backdrop, the reputation of companies will also be at stake if it is open proceedings. But if it is mediation or the arbitration, these proceedings will not be open. It is within the four walls, and this information will also not go out as well. And as a result, there will be no deterioration of the parties' relationship, and ultimately their reputation is also not at stake. These are some of the advantages when it comes to the Mediation Act of 2023. Similar such advantages are also with the arbitration as well. Now what we have to understand is that, is it an absolute in nature that they always have to go to the mediation? No. As I initially told you, in case there is an exigency, they require an injunction or a stay order, they would be able to go to the courts, seek for the injunction, and ultimately reciprocate back to what is called as the mediation center. Now what is the difference, or what is the similarity between arbitration and the mediation? The position, mediation is similar to the commercial arbitration. So both the arbitration and the mediation will be similar. They will impose stringent timelines for the conduct of the proceedings, as we discussed, 120 plus 60. This is the timeline that is required for the mediation to completely get over. So it is a timeline that is prescribed both for the arbitration as well as for the mediation. Mediated settlement agreement. So what you will have in the mediation is called as a mediated settlement agreement, and when it comes to arbitration, it will be called as an arbitral award. And when it comes to mediation, what we will have is a Mediation Council of India, equally mirroring the proposal in 2019 to establish the Arbitration Council of India. The Arbitration Council of India is yet to be appointed and we need an institution, but with the coming up of the Mediation Act of 2023, what we have is the Mediation Council of India, which will be established. These are the similarities between the mediation and the arbitration. So what is the intent of the Mediation Act of 2023? That the Parliament has devised the Mediation Act of 2023 primarily to say, first you explore the options of the mediation, see if things can work out, and only if things cannot work out, that is when you approach court as the last resort. So the intent of the Parliament in the production of the Mediation Act of 2023 is basically to ensure that there is no cases that comes up to the court prior to exhausting all options. So exhaust the alternative dispute resolution mode first, make sure that you go to the mediation center only if you cannot finish off this case, end the litigation in the mediation, that is when you approach the court. Till then, go there, finish it off, so that you do not have to put the stress to the judiciary as well, and this costly affair can also be reduced. It is this that we have to understand with respect to this article. Now let's look into the next article. This article here is speaking about United States of America's dilemma when it comes to the West Asian politics. What is happening of late? When you look at the West Asian politics, you also have the involvement of China. So whenever there is involvement of China, what is that United States of America will have to do in that area is the focus of this article. We have two important points that we have to consider. One is with respect to what is called as the Abraham Accord. The other is with respect to the recent corridor initiated during the G20 summit. Let's understand this article in greater detail. The first part of the article speaks about the India, Middle East, Europe Economic Corridor. This economic corridor was initiated by the United States of America. We have discussed about this economic corridor in detail. What is this economic corridor? This economic corridor happens to be a transport corridor. We have discussed in detail in our earlier DNAs. So what we will discuss today is in brief. So this happens to be a transport corridor where we will make use of the railway connectivity, road connectivity, as well as the sea communication. From India, we have to export a certain commodity. So what do? We make use of the sea lanes. We export the product from India to Western Asian countries like Saudi Arabia, UAE, so on and so forth. From these Western Asian countries, we further export it to the European countries. So what we have is a transport corridor, economic corridor, where we would be able to export goods from India to West Asia and from West Asia to European countries. So this is taken up by United States of America to promote economic prosperity. At the same time, US delegation had also visited Saudi Arabia, chasing a normalization agreement between Sunni kingdom, that is, which happens to be UAE, as well as the Jewish state of Israel. This is with respect to the Abraham Accords. What is this Abraham Accords? We had Israel and we also have United Arab Emirates. The Arabian nations, that is, you have couple of countries like UAE, you also have Saudi Arabia, do not have good relationship between Israel as well as all these Arab countries. But what did Trump administration do? The Trump administration was able to establish a connectivity, able to establish a diplomatic connect between Israel and UAE. This is what is called as the Abraham Accords. What is this Abraham Accords? This basically meant that you have Israel, which was not in good relationship with UAE. So establishment of the diplomatic relationship between Israel and UAE can also be further extended with Israel as well as Saudi Arabia. So what the US has been able to do is there is a Trump era policy. One is with respect to the Gulf Arab as well as Israel. So extend it, continue this very policy. So the United States of America is continuing the policy with Israel and UAE, and an extension of it is with respect to the Saudi Arabia. This is on one side. So what is happening in West Asia? United States of America is trying to ensure that its presence is constantly felt in United States of America. How? It is trying to bridge the differences between Israel as well as Saudi Arabia and United Arab Emirates on one side. On the other side, we recently also had the I2U2. What does it stand for? It stands for India, Israel, US as well as UAE. So you have I2 which stands for India and Israel, U2 which stands for US and United Arab Emirates. Again, through this mechanism, what has it been able to do? It has been able to mold a connection between its allies. So there are three parts here. One is with respect to India, Middle East, Europe Economic Corridor. Second is with respect to the Abraham Accords. Third is with respect to the I2U2. With all these mechanisms in place, there is West Asian politics. The West Asian politics, you have United States of America, which is making its presence felt with all these allies. Now United States of America is also deprioritizing what? United States of America is withdrawing its forces. When I say withdrawing its forces, it was acting more in West Asia, but now it is building a relationship with its allies. It is slowly withdrawing. The amount of commitment it had before, it is slowly reducing. Why? Because it is wanting to focus on two other areas. One happens to be Eastern Europe, the other happens to be East Asia. What is happening in Eastern Europe? One is with respect to Russia and Ukraine crisis. The other is with respect to China. With respect to China, you have the North Korean crisis. You also have crisis in the South China Sea and also in the Indo-Pacific region. So what United States of America is trying to do is, it is deprioritizing West Asia region so that it can focus more on the East Asia region and the East European region, because that region is currently having a lot of turmoil. So in order to make sure that United States of America's presence in West Asia is not completely taken off, it is working with its allies in the West Asia so that it can focus in the Eastern Asian region as well as the Eastern European region. So the intent is all the concentration prioritization was there with respect to West Asia. Now it is slowly withdrawing because it feels that its allies would be able to manage the West Asian crisis on a whole, and that is why it is slowly withdrawing. It is not withdrawing completely, but it is trusting its allies to conduct its activities in the Western Asian region. This is where the author goes on to say that it can be a problematic approach. Why is it a problematic approach? United States of America is trusting its allies in the form of United Arab Emirates, Saudi Arabia, and then it is slowly withdrawing from this area and moving to East Asia as well as East Europe. This could be problematic primarily because you have China, which has increased its presence in the Western Asian region. China is dependent on the imports from Saudi Arabia and United Arab Emirates, where 70% of its oil requirements is met by the Arab countries. Recently, when you look at what China has been able to do, it has also been able to mold relationship between Iran and Saudi Arabia. Iran and Saudi Arabia do not have good relationship. So China is trying to act as a friend in helping bridge the differences between Iran and Saudi Arabia. China is now trying to fill the vacuum that United States of America is planning to withdraw. So this ultimately means that the approach of United States of America may be wrong or may be right. But according to the author, he goes on to say, since United States of America does not have good relationship with Iran, Iran will not listen to United States of America. But if China says, Iran may listen to it, and at the same time, China also has good relationship with Saudi Arabia. So if United States of America withdraws, that means China will fill in that particular vacuum and the West Asia may fall under the kitty of China is one such argument. To prevent it, what United States of America is doing, it is forging closer relationship with its allies and it is wanting to strengthen the US security architecture. There is another issue as well. When you go back to the Cold War era, the 1970s, 80s as well as the 90s and even the 1919 as well, much prior to 2000, you had United States of America which was able to control the larger part of the Western Asia, and this ultimately meant whatever the Western countries said, that is United States of America said, the Western Asian countries were listening to it. But right now that is not the go ahead. Why? Because these countries like Saudi Arabia, United Arab Emirates are acting as independent agencies. They are discussing everything on their own independent basis and they are looking at what is good for them. For example, the Saudi Arabia and United Arab Emirates are settling the differences between Iran, and Saudi Arabia led there is blockade of Qatar that was with respect to Saudi Arabia that has been released, and there is Arab conciliation with Syria's Bashar al-Assad. Saudi Arabia and UAE are also trying to formulate policies independent of the US goals. These countries are also wanting to become part of BRICS as well. America's diplomatic push or economic integration plan has been accepted by these countries, but they not remain the client stage. They will not remain the absent stage. They will not just listen to United States of America, but they will think independently and act independently. And as a result, United States of America, if it prioritizes other places and slowly withdraws from the Western Asian region, is not right, says the author. So the Biden administration, despite its limited engagement, continues to see Iran as a hostile power, which is the major impediment for United States of America in the Western Asian region. So what is that India can do amidst all this crisis? While United States of America is deprioritizing, we have China, which is stepping into picture as a trusted ally of United States of America. India can fulfill United States of America's vacuum. So the author goes on to say, India has good relationship with Russia. India has good relationship with Iran as well. United States of America may not have good relationship with Iran, but India has good relationship. So India can withstand the pressures of China as well, and it can fill in this vacuum if so United States of America deprioritizes Western Asian group. So what have we done? India as of now has INSTC, that is North-South Transport Corridor, where we are in good terms with Iran as well as Russia, and we also have Middle East Corridor as well. So India should focus on multi-engagement, which it is currently focusing, and should continue to fall on multi-engagement, not in appeasing or containing any great power, but it has to be part of all powers as well as all groups, is what is this article all about. So if United States of America is withdrawing slowly, deprioritizing West Asia, it is expecting that allies step into picture, but this is going to be a troublesome process because China is also stepping up and increasing its presence in the Western Asian region. So if India wants to, and if United States of America wants to deprioritize, India can step into and create that particular aura for itself in the Western Asian politics by multi-alignment. Multi-engagement is what is this article all about. Now let's look into the next article. This article says sports ministers will skip Asiad inaugural as China bars entry of Arunachal Pradesh. China is one hostile country. It believes in antagonism with every other country, and it also wants to stamp its authority everywhere, but that stamping of authority will not work for India because India has its own rules that it works with. There were 3 athletes from Arunachal Pradesh. Let me tell you this, that Arunachal Pradesh is always a part of India. It will be part of India for eternity. When Arunachal Pradesh is part of India, mind you, irrespective of which part the athletes come from, they have to represent the country and they have to play for the country in any of the games as well as sports. But then 3 individuals from Arunachal Pradesh wanted to represent India and they go to this Asiad Games, but then they were not allowed entry by the China as a sign of disapproval. Our sports minister will skip the Asiad inaugural, says this article. So Union Sports Minister Anurag Thakur has cancelled his visit to the Asian Games due to China's denial of entry to Indian Wushu players from Arunachal Pradesh, even as the government registered official protest at Dishan. 3 players include Neiman Wangsu, Onilotenga, Mepungul Lamgu, who were refused entry despite having e-accreditations from the organizers. So these 3 individuals were not allowed to enter China and they were not allowed to represent our country because they are from Arunachal Pradesh. Arunachal Pradesh has border issues between India and China, and as a result, since China does not officially recognize Arunachal Pradesh to be part of India, they have not allowed these 3 individuals from entering and playing this Asian Games. This is where we have to understand another concept called as the staple visas. What are these staple visas? This happened in the year this happened recently in July as well, where these athletes were also given staple visas. What is this concept of staple visas? As you can see, whenever you have a passport, you will be given a visa. A visa is a permission by another country that so and so individual from so and so country would be able to attend so and so event or as part of the tourism. So when you take your passport, what would happen? You would give the passport to the airport authorities, and what they will issue is a stamp on the passport which says that you as an individual have made a visit to so and so country. So the minute you go to the airport authorities will stamp on your passport. So instead of stamping on the passport, there are issues with respect to China. What it issues is called as the stapled visas. So visa is a permission issued by another country so that you would be able to enter that particular country. After you enter that country, you will have a stamp on your passport. But when it comes to staple visas, if a person is entering another country, there will be no stamp on the passport. The passport will not have the stamp of the foreign country, which means they will be issued this piece of paper which can be detached. There will be no stamp on the passport, which is called as the stapled visa. Stapled visas basically means a paper will be attached to the passport. It can be detached, it can be removed, and on the passport of that individual, there will be no presence that this person entered another country or not. So when it comes to the normal process, you give your passport, there will be a stamp on that particular passport which gives you information that this person traveled to so and so country for so and so period. But when it comes to stapled visas, it is just a piece of paper. There will be no stamping on the passport, and all that you would be able to do, you would be able to detach it as well. When it comes to the month of July, what we saw was Chinese embassy and the Chinese officials had issued stapled visas to our people, that is for those who are representing India from Arunachal Pradesh. Is it the first time that it is happening? No, this happened in July, and much prior to that it has happened couple of times as well. In 2011, an official from the Indian Weightlifting Federation hailing from Arunachal Pradesh and a weightlifter from the same state were to travel to China to take part in Grand Prix event in China, but they missed out after they were issued stapled visas. The same year, 5 karate players from Arunachal Pradesh who went to travel to China for a championship met with the same fate. In 2016, Bamang Tago, the manager of Indian badminton team, said he did not get a Chinese visa to travel to Fuzhou for the China Super Series Premier Tournament because he was from Arunachal Pradesh. So the Chinese have stopped people who are from Arunachal Pradesh representing India from entering China, and in the past they have issued staple visas so that these people's passport do not have any stamp on it. In order to fight this, what Shashi Tharoor comments is where a valid reason. Enough is enough. Instead of frustrating our sportsmen and every other Arunachali seeking a Chinese visa, we should simply start issuing staple visas ourselves to anyone applying for an Indian visa from Tibet, and say we will continue to do this until the disputed border between Tibet and India is also settled. So this is the response given by Shashi Tharoor ji. So the article says that such ideas, such promotions of the Chinese is not the right way ahead, and this has to be stopped, is what is this article all about. Now let's look into the next article. This article says people's count. The article here is speaking about the census. The census here happens on a decadal basis. India has conducted census every 10 years since 1881, but in the year 2020, census could not be taken up primarily because of the COVID-19. Since we were not able to take up the census in COVID-19, it has been pushed, it has been extended, it has been postponed, and as a result, we do not have the data. Now, the government has gone on to say that census will take place only after 2024 election, because many people are also asking for the census data that has to be given with respect to the caste, since it could have turmoil in the Indian politics. That is why after 2024 elections, census will be conducted. This decennial census will be conducted, is what is this article all about. So basically, the article goes on to say that such postponing of the census may not be right, because the census data is very much required for planning of a program, for execution of a program, where funding has to be implemented, so on and so forth. So only when we have the census data, we would be able to plan to the optimum level, enforce a
particular policy for a certain group of people, where the group of people are lacking behind, where they are present, in which part of the country they are present. All this can be accessed only through the census. So what we require is the census. Apart from this, whenever you're speaking about census, you will also have census which is conducted either on the paper or digitally. For the very first time, what we will have is census which will be conducted on a digital basis. So for the first time, for the year 2021 and subsequently after that, what we will have is the digital census. This is also important from the preliminary examination point of view. So what is the gist of this article? The gist of this article is the government should expedite this census process so that the numbers that is taken, the data that is taken is ultimately used for effective implementation of the policy program, so on and so forth. Now let's look into the next article. This article says Quad ministers hold talk on rules-based order. We had the Quad ministers who met up recently. Which are the Quad countries? We have India, United States of America, Japan as well as Australia. These countries met together and they also wanted to reform the entire institution of United Nations, and they also wanted to make sure that there is rules-based order in the Indo-Pacific region. So the Indo-Pacific region currently is full of acrimony between countries in South Asia region. That is, you have the South China Sea, you also have countries, Asian countries who do not share good relationship with China, primarily because China says this entire South Sea China Sea belongs to China, and there is skirmishes and issues and tussles between these countries as well as China, and then they are also not allowed to move freely in the Indo-Pacific region. So the Quad countries have basically saying that when it comes to the Indo-Pacific region, what we need to follow is the rules-based order, and that rules-based order is only being stopped by the agrimony and the Chinese domination. This has to stop, and what we require is the free rules-based order that has to be enforced in this part. So this article goes on to conclude that what we require is the Indo-Pacific region which is free of all these tussles, and China has to follow this rules-based order. Is what is this article all about? It is this that we have to understand with respect to this article. So in case you are liking these initiatives, please do like, subscribe to our YouTube channel and share it with your fellow aspirants as well. So this is it for today. Thank you for watching. All the best.